This is a Channel 2 News special report.
Well, he's vowing not to resign in his financial...
Here to release amounts to 40 pounds and 10,145 pages.
This is the Senate Ethics Committee's news conference this morning. They had planned to announce their reasons for voting unanimously to recommend expelling Oregon Senator Bob Packwood from the Senate.
Get it in the Packwood case. Well, there can be no doubt today that the Ethics Committee got it concerning the gross and persistent misconduct demonstrated by Senator Bob Packwood. First of all, no workplace in America ought to tolerate the kind of offensive, degrading sexual misconduct that the Ethics Committee finds Senator Packwood to be guilty of. And it certainly cannot be tolerated in the United States Senate either. These were not merely stolen kisses, as Senator Packwood has claimed. There was a habitual pattern of aggressive, blatantly sexual advances, mostly directed at members of his own staff or others whose livelihoods were connected in some way to his power and authority as a senator. In at least some of the 18 instances of which we find Senator Packwood guilty, he used physical coercion against his victims, frightening them and causing them severe emotional distress. This cannot be tolerated in the United States Senate. Second, we find Senator Packwood guilty of using his position to benefit himself financially. By soliciting jobs for his wife, he was divorcing in order to cut his alimony payments. These jobs came from individuals who had a direct interest in legislation that Senator Packwood was in an ideal position to influence. The Justice Department was unable to find conclusive evidence of a quid pro quo in these transactions, and therefore declined to prosecute Senator Packwood for job solicitations. But as the Ethics Committee has held in many previous cases, misconduct does not have to be criminal, or even a violation of the Senate rules specifically, to be deserving of punishment for bringing discredit and dishonor upon this institution. These first two categories of misconduct which I've discussed constitute egregious abuses of Senator Packwood's power and authority. At the very least, they require that Senator Packwood be stripped of all the power and authority which he has consistently abused. But this case is not only about severe misconduct. It is also about a deliberate effort to cover up important evidence relevant to that misconduct. Specifically, the committee finds Senator Packwood guilty of endeavoring to obstruct and impede the committee's investigation. First, by failing to produce his diaries in response to the Ethics Committee's document requests, and then by deliberately altering and destroying relevant portions of his diary transcripts and tapes. Not only do the transcripts and tapes bear witness to these systematic alterations, but Senator Packwood's own transcriber testified to the committee that Senator Packwood admitted to her that he had made extensive changes with the knowledge that they were relevant to the committee's investigation. Such conduct is clearly illegal, violating Title 18, Section 1505 of the U.S. Code. If this were a criminal court, Senator Packwood would likely receive 10 to 16 months in prison as a first offender under the federal sentencing guidelines. The law itself allows prison sentences of up to 5 years. This is a gravely serious offense. Historically, the Senate has waited until a member has actually been convicted of a felony before expelling a member. In this unusual case, however, the crime was not committed out there, if you will, out in society, but it was committed in here. The crime was committed against the Senate itself. against its own disciplinary process. As a result, the Senate is the proper judge of whether Senator Packwood committed a crime deserving of expulsion. Therefore, the penalty in this case, while extremely severe, is both justified and, in my view, entirely consistent with past precedent. As I've said, the Senate has always required a criminal conviction as the predicate for expulsion. The committee's recommendation is consistent with that requirement, although in this unusual case, the Senate was in the best position to determine that the crime had occurred. There was no need to have the Justice Department tell us that our internal disciplinary process had been illegally flouted and obstructed. When individuals become senators, they take an oath of office to defend and uphold the Constitution of the United States. Article 1, Section 5 of the Constitution stipulates that the Senate has the duty and authority to investigate and punish unethical behavior by its members. Senator Packwood's systematic effort to obstruct and impede the Ethics Committee's inquiry demonstrates utter contempt and disregard for the Senate's constitutional self-disciplinary process, and as such is a violation of his oath of office. This is why I personally offered the resolution to expel Senator Packwood, which was approved unanimously by a vote of the Ethics Committee. Now Senator Packwood is claiming that he was denied the right to confront and cross-examination the victims in an open hearing. This is patently false. On June 29th, Senator Packwood was expressly given the opportunity to request a public hearing, as was his right under the Ethics Committee rules of procedure. He had 5 days to think about it. And on July 5th, Senator Packwood informed the committee that he did not want public hearings and that he waived his right to them. Then on July 31st, as you well remember, the committee voted not to have public hearings, and on that very same day voted to release all relevant evidence in the case, which is here before you. 2 days later, on August 2nd, the full Senate voted down the Boxer resolution to compel public hearings, and Senator Packwood himself voted against public hearings in his case with full knowledge of the committee's decision to release its evidentiary record. The factual record on which the committee reached its decision to recommend expulsion is no different than it was when Senator Packwood indicated not once but twice that he did not want public hearings. And let me just say, to the argument that cross-examination has now become indispensable. Why was cross-examination not indispensable the first time he made a decision not to have public hearings, and the second time he voted not to have public hearings? Although the committee did receive 2 additional complaints, investigated them and found them to be highly credible, they are not a part of the factual record that caused the committee to recommend expulsion. Thus, for Senator Packwood to claim that he was somehow denied the right to confront and cross-examine his accusers through public hearings is completely contrary to the facts. As happens with increasing frequency these days, the victimizer is now claiming the mantle of the victim. The one who deliberately abused the process now wants to manipulate it to his advantage. That won't wash. The committee has heard enough. The Senate has heard enough. The public has heard enough. The evidentiary record weighing in, as I said, at 40 pounds and 10,145 pages is here for everyone to see. Now is the time for justice to be done.
Yesterday's decision by the Senate...
This is Senator Richard Bryan now of the Senate Ethics Committee.
...exhaustive and thorough investigation. It is a decision, in my judgment, which renders justice to Senator Packwood, justice to the Senate as an institution, and justice as the American people have a right to expect. None of us as individual members take any personal satisfaction in this, but it was, in my judgment, a duty that was incumbent upon each of us to discharge. I think each of us, as we examined the evidence during the course of these many months of investigation, became increasingly appalled and shocked by the overwhelming evidence that began to pile up against Senator Packwood. And I think that each of us, in our own way, reached the conclusion that expulsion was the only appropriate course of action. For me, I reached that conclusion earlier this summer as I again reviewed the documents that had been collected over the 2 preceding years and prepared to vote on charges that the committee would submit to Senator Packwood. And I think that increasingly, as this evidence unfolded, other members reached the same conclusion. I shared that view with the chairman of the Ethics Committee yesterday morning, that it would be my intention to offer such a resolution at the Ethics Committee yesterday, and as the chairman has indicated, he made the motion and it was unanimous. I think it needs to be said that no one event or element in this case caused this outcome. The decision for expulsion was reached based on the accumulation of evidence showing misconduct in all 3 areas that the committee was investigating. What Senator Packwood said or did not say over the last few weeks did not result in this outcome, nor did anyone charge. The Ethics Committee had not discussed sanctions until yesterday, and when we did, we found ourselves in complete agreement on what we should recommend. Senator Packwood gave 2 lengthy depositions to the committee and appeared before the committee members for 3 days to answer our questions. In that appearance over the course of 3 days, nothing he said justified or disproved any of the charges that have been brought by the committee. And it is my view that once the committee sees the evidence that the chairman has pointed out here, that the committee will reach the same, or rather that the public will reach the same conclusion as the committee, that expulsion is the only course of action that would be acceptable. There are some things when this evidence is released that the public is going to learn about which involves behavior that is unseemly for anyone, much less someone who has been entrusted with one of the highest public offices of the land, the United States Senate. I want to say as strongly as I possibly can that the conduct that we find Senator Packwood guilty of is unacceptable. Unacceptable in any workplace in America, unacceptable in the United States Senate. His exercise of power over those he controlled was reprehensible. I want to say something to the women who came forward to the Ethics Committee. I know this has been an extremely unpleasant experience for each of you. I'm the father of 2 daughters, very proud of those daughters. One of my daughters worked as a member of the staff in the United States Senate. I believe what the Ethics Committee has done yesterday, and what I hope that the Senate will do on the floor of the Senate when this matter is brought to the Senate, can make a difference for women in America as they continue their careers, whether in the private sector or in the public sector. This case has a number of historic firsts. No Ethics Committee in the history of the United States Senate was ever forced to subpoena documents from a senator under investigation. No Ethics Committee in the history of the United States Senate had ever been required to spend a year in court to obtain requested information to complete that investigation. And no Ethics Committee in the history of the United States Senate has ever submitted a recommendation for discipline on charges of sexual misconduct to the full Senate. Now it is time to move ahead and put this sad chapter behind us all. I am hopeful that Senator Dole will give the Ethics Committee time, hopefully next week, so that this matter can be brought to a conclusion. I want to respond very briefly, as did the chairman, to some of the comments that Senator Packwood made yesterday and has made over the past few weeks. First, with respect to the assertion that there are some anonymous charges that he knows nothing about, let me just say that the Ethics Committee provided the Senator with the names of all of those who were complainants and upon whom we based the 18 allegations of sexual misconduct involving 17 women. Regarding his comment that he was found guilty of kissing women, when you have examined this record, the record is explicit and detailed in terms of the assaultive behavior that Senator Packwood was guilty with respect to some of the women who filed these complaints. And finally, let me say that Senator Packwood's version of the handling of the diary material is totally incorrect. Senator Packwood provided altered diary materials to his attorney without making the attorney aware that he had in fact altered the content. The only reason the committee did not receive altered materials was that the review process of the diaries by the committee was terminated by Senator Packwood in October of 1993, before Senator Packwood's lawyers had turned over the altered diary material that Senator Packwood had provided to his attorneys, and which would have reasonably have been expected to be turned over by his attorneys to the committee. Clearly, Senator Packwood intended for the committee to receive the altered documents, and his conduct was designed and calculated to mislead and to deceive the committee in the most material aspects of this investigation. Senator Packwood first withheld relevant documents from the committee despite two document requests, as the chairman has indicated. He then altered the material he knew was relevant to the inquiry, and then he and his transcriber deliberately altered tapes after the transcriptions had been given. With respect to the jobs matter, every member of the United States Senate knows that no matter what one's personal relationship is, public officials cannot solicit or arrange personal financial support from those who have business before the Senate. If we need to prove our charges before the Senate, this committee is fully prepared to do so, and the case will speak for itself. Now, Senator McCall and I would be happy to respond to any of your questions.
Senator McCall, what specifically convinced you to go for expulsion, and when did you decide to do that?
Well, first let me say I think that most of you underestimated the significance of the charges from the beginning, and I say that not to put you down, but the alteration of documents, the violation of 1505 of Title 18 of the U.S. Code, which was made apparent in the Bill of Particulars back in May, should have suggested to you that this was an extraordinarily serious case. Over the summer, I wrestled with what I thought was appropriate. Candidly, I never thought anything less than loss of chairmanship was in the offing. And all of us had to weigh, particularly over the month of August, I think, just what we thought was the appropriate response to a deliberate attempt to deceive the committee in clear violation of criminal law. And as the vice chairman indicated by yesterday, obviously, actually by several days ago, I did not tell him that, but by several days ago, I had decided to offer the motion that I did.
Senator McCall and Senator Bryan, does the committee intend to request that the Justice Department conduct a criminal investigation of the destruction of a congressional investigation?
We really didn't discuss that. I don't know whether they would want to pursue that after expulsion had occurred or resignation had prevented expulsion. That would be up to them, I suppose.
Is that a bargaining chip?
Frankly, we didn't discuss it. We were concerned about what the Senate's response to this ought to be, not what any other agency of government might conclude ought to be appropriately done.
Senator
you believe that Senator Packwood is suffering from delusions about the seriousness of the charges or his chances of getting through the Senate successfully? Should he just resign now and save the Senate from embarrassment?
Yeah, I'm not going to speculate about what he may be suffering from. I think the evidence is compelling, and it seems to me the appropriate response would be resignation.
Senator McConnell, if this case was so serious, why did you oppose public hearing?
Well, let's go back over that. We spent a couple of months on it. First, if you will recall, and only one of you, I think, wrote, the professional staff of the committee felt that hearings were not necessary. Second, because we had everything before us we needed to make a decision. And my view was we ought to move on to the decision phase, and frankly, but for the flap over public hearings, we would have reached a decision in late July or early August rather than in September. My own personal view was that nothing was to be gained by putting on what I think we all agree would have been an extraordinary show, which would have diverted the Senate from its responsibilities. And I never felt that was necessary to achieve a just result in this case. And I think the action that the committee took yesterday demonstrates that it was not necessary to achieve a just result. At the risk of being redundant, let me also repeat that the notions that Senator Packwood has expressed last night and this morning, that the loss of right to cross-examination was critical, was something he had to have been aware of at the time he waived his right to a hearing the first time, and had to have been aware of at the time he voted against the Boxer Amendment later. And of course he knew that we were going to release this information right here, which we said we were going to do the same day we voted not to have public hearings. To sum it up, I didn't feel that public hearings were an indispensable part of reaching a just decision. The committee differed on that issue, but we managed to move ahead.
How did you react, though, when Senator Packwood then called for public hearings, and all these Republicans had gone on the record saying that they had gone out on a limb for Senator Packwood, saying that they didn't want public hearings?
Well, obviously, I didn't agree with that decision. The issue was
feel betrayed by that?
Well, I'm not going to express my feelings about it. I mean, obviously, having argued that on the floor and having voted that way on the committee, I disagreed with the decision. And I continued to disagree with it even after the senator decided at this late hour that he wanted to go in a different direction. I mean, I could only conclude at that point that that was an effort to delay the process because I believe, I guess I'm not sure everybody would come to the same answer on this, but I believe it would have taken probably 4 to 6 months to have gone through the public hearing process, and I thought we already had what we needed to make a decision. Let me just, the staff sent me a note. Apparently the criminal referral was approved and is required under Rule 8 of our Rules of Procedure, so that is the answer to that question.
It's in the resolution.
That's already been approved?
Yeah.
The resolution has been adopted that contains the language of referral.
Senator, as you know,
That was yesterday's resolution.
Let's take one at a time. Mr. Franklin.
The Anita Hill hearing in the Senate, particularly in matters of sexual assault and sexual matters, has taken kind of a battery that's in the last several years. What do you think that this does for the Senate in your action that you take? What does it say about this?
We'll both comment.
I would respond by the substance. It seems to me that what the committee has done in its action by a unanimous consent was in the first instance to file by unanimous agreement a series of some 18 charges filed by 17 women alleging sexual misconduct. That in itself represented a historic first, and I think was the first indication publicly that the committee viewed this as serious and that this type of conduct was simply unacceptable. The action taken yesterday by the committee, again by unanimous consent of all members, indicates that the Senate has zero tolerance for this kind of conduct and should send a message to every woman in America that the United States Senate recognizes that this conduct is unacceptable and will exercise the ultimate sanction. This is the atomic bomb. We can do no more than to expel a member and to refer this conduct to the Justice Department.
To follow up, does this reflect an evolving or a changed attitude?
You are watching Channel 2 live coverage of the Senate Ethics Committee news conference explaining its recommendations to expel Senator Bob Packwood from the U.S. Senate. The senator, for nearly 3 years, having undergone sexual harassment accusations. These now are the results of the Senate Ethics Committee.
Committees that follow, and other members who may succeed Senator McConnell and myself in these respective positions, that the Senate has spoken loudly and clearly, and sexual misconduct will not be tolerated in any form.
Let me just, if I may just follow up very briefly. I think the message here is the Senate has zero tolerance for criminal conduct.
Mr. Chairman, if I could just follow it, in light of the seriousness of these charges, if Mr. Packwood follows your advice and he resigns, he would still be able to keep a rather generous pension versus if he is expelled. Do you think it's appropriate to be able to keep his pension in light of these charges?
To be perfectly frank with you, I hadn't really thought about that aspect of this, and I'm sure we will think about it in the next couple of days. I don't have any reaction to that.
Senator Bryan said we don't have to guess here or misinterpret. You said that we're going to find things right there in those records that are, quote, unseemly for him. Tell me what you're talking about.
Well, I think we're unseemly. I think, unlike Senator Packwood's characterization that the sexual misconduct involved kissing, the record will reveal in explicit detail the nature of those encounters that Senator Packwood had with each of the 17 women. I believe that any fair-minded reading would lead one to the conclusion that this is unseemly conduct, outrageous conduct, intolerable and unacceptable conduct, and ought to have an appropriate sanction. And that is what we concluded.
Packwood says the statute of limitations for this sort of thing has brought out these happened years ago.
Let me respond to that. Senator McConnell and I, in the last session of the Congress, he appointed by Senator Dole, I appointed by the then Majority Leader Senator Mitchell, reviewed the ethics process, not with respect to any one case, but overall. And among the issues that was discussed was whether or not there ought to be a statute of limitations. Again, not with respect to the Packwood matter in particular, but just in general. We called witnesses before the committee who had served as counsel to the Ethics Committee as special counsel. We called witnesses before the committee who had represented members of the United States Senate in ethics matters. Each of those lawyers, some representing what might be considered a prosecutorial and a defense view, were asked the question, should the Senate of the United States impose a statute of limitations with respect to misconduct? Each of them agreed that it would be highly inappropriate, that statutes of limitations do not relate to ethical matters and ought not to relate to ethical matters because the Senate ought to have the ability to judge all of the conduct before it. And in this case, I think it's important to note that the committee found a pattern of conduct from 1969 down to the most recent event that indicated that sexual misconduct was part of the pattern of Senator Packwood's conduct of his official duties.
Let me just follow up on that. I agree with the Vice Chairman that there should be no statute of limitations in Senate Ethics Committee cases. It was envisioned that the 3-3 nature of the committee would certainly protect a senator against an ancient, isolated, inconsequential event. But as the Vice Chairman has said here, there was a pattern of conduct over a lengthy period of time, and clearly the Senate should adopt a tougher standard, and there is no arbitrary statute of limitations in a Senate Ethics Committee proceeding. You could take into account, obviously, the age of the complaint as a factor in deciding whether to go forward with a case which would require 4 votes of the committee.
Senator McConnell, have you spoken to the Majority Leader yet about a time frame for bringing these cases?
I spoke to him only after I spoke to Senator Packwood yesterday. Senator Bryan and I both visited with Senator Packwood yesterday afternoon in his office after the committee rendered its decision. At that point, I went to see Senator Dole and explained to him what the committee had done. And as you all know, floor time for this matter will be up to him.
Is that the only conversation you had with Senator Dole? counsel, you will recommend Senator Packwood to resign?
Senator Dole didn't say anything at all to me about what he planned. He listened to my presentation. He did not tell me what he planned to do, either with regard to scheduling floor time for the committee's recommendation or any other matter related to the case.
Time, Senator McConnell, have you ever discussed punishment with Senator Dole?
No, I did not discuss this with Senator Dole. He had no prior knowledge of my decision in this case. In fact, he learned about it after Senator Packwood learned about it.
How did Packwood react when you went to talk with him about this?
Well, I think that I just would say that Senator Packwood had a couple of questions about the process that he asked us about, and Senator McConnell and I tried to respond as best we could.
Senator Bryan, can I follow up on this question of a criminal referral?
Yes.
You said that the rules of the Senate required a criminal referral, if I understood you correctly. So that's incorporated in the resolution?
It is incorporated. It is incorporated in the report, as I understand it. Correct me if I'm wrong. The report. It is in the resolution, and that was acted upon yesterday unanimously by the committee.
Can it be deleted from the resolution, or could the committee agree, for example, not to make such a recommendation to the Justice Department if Senator Packwood would resign?
Well, of course, whether or not they would pursue it would be up to the Justice Department, if that's your question. I mean,
but I'm asking whether the Senate would could decide not to refer the matter to the Justice Department.
Well, I mean, the Ethics Committee has already made its decision, and this decision is irrespective of what the full Senate might do with respect to the penalties that we've recommended. We have made a decision to refer this to Justice Department. I can't conceive of the circumstance. Yeah.
Whether or not our rules, I'm told our rules require us to refer it. Whether or not we referred it, if the Justice Department decided to pursue this, they could. I mean, we don't control what they pursue, so I'm not sure our decision to refer, which our rules require, isn't going to keep them from pursuing it if they wanted to. Even if we'd not done that, they could pursue it if they wanted.
The question is, if he resigns, do you still have to make that referral?
Well, that's part of our action. We've already taken the action.
We have to make the referral, but if you're asking, can we control what the Justice Department does, the answer is no.
And the other part of that question, if I might respond further, I mean, if Senator Packwood resigns, that would not per se terminate the Justice Department's right to pursue it. In other words, his resignation does not terminate their ability to proceed.
If Senator continues to fight, does that mean there's a possibility of public hearings, or what's the next step?
We've already crossed the
We've made a recommendation. That issue's over. We've made a recommendation. Hopefully, if there is no resignation, our resolution will be approved by at least 67 members of the Senate. That is our hope.
What do you do to hear from our constituents?
Has Senator Dole given you any indication whether he'll put forward to now that we made this recommendation?
I think I've already answered that question. Senator Dole did not learn about my position until after Senator Packwood did. He did not express his view on the issue. He listened.
Is that motion debatable on the floor?
Yes.
Yes.
Oh, yes.
Senator, you said that now is the time for justice to be done. If Senator Packwood were to resign with his benefits, would justice be done?
Well, I really haven't thought about the benefit issue, and that's already been asked. I really just haven't thought about that, and I'm not prepared to take a position on that.
He appeared before you behind closed doors, hurt him. Did he express remorse, able to do so?
I commented with respect to his testimony that I found that his testimony, in my judgment, was not persuasive on any of the issues that we had filed the charges. The sexual misconduct, the solicitation of jobs, and the deliberate and calculated effort to deceive the committee. And that's all I would say, is that I did not find anything in his testimony that persuaded me that the actions taken by him in each of these three categories did not warrant.
Sorry, I did some of these things. I made mistakes.
Yeah, I think that our action yesterday speaks more loudly than anything we could say now about our view of his position in this matter.
3 years to complete this.
Yeah.
Do you have any regrets that, given the seriousness of the charges and now the sanctions, that it took almost 3 years to complete?
I'm glad you asked that. It takes a while to interview 264 witnesses. I've got my little list here. I want to give it to you again, if I can find it. 264 witnesses, 111 depositions, 44 subpoenas, That can't be done overnight. And also let me remind you that we lost 10 months as a result of Senator Packwood's fighting the subpoenas to get the diaries, which was taken all the way to the Supreme Court. So we were confronted with a choice, and I hope you will listen to this. We could have either done an incomplete investigation, in which case you all would have been here asking us, well, why didn't you talk to everybody? We decided the most important thing to do is to have a thorough and complete investigation, the results of which you see right here, so that we could stand before you at the end of this case and say that we pursued every lead and we came to a conclusion based upon a total investigation. And so I think it is pretty unfair to, after doing such a thorough job, to be criticized for taking so long.
But let me just add, if I may, to what the chairman had to say. I associate myself with his comments. One additional factor that will appear when you read the record here is the handling of the diary material itself. First of all, we did not know initially what the circumstances would be. There is an original tape that we learned of only in late November of 1993, after Mr. Packwood's then lawyers, Arnold and Porter, made us aware of that. There is a transcript. Obviously, there are missing altered diary tapes, and so all of this had to go to the Justice Department for them to review, to compare, before that information was provided to staff. Mr. Starr, as you'll recall, was our special counsel. In addition to the delays which the chairman has addressed, it took months. We did not receive the last of those diary transcripts until earlier this year, January or February, and staff will correct me if I'm wrong, but I think it was January or February of this year when we received the last. Is that correct? That is correct. So that accounts for the delay. Did what? Well, the diaries were altered, in our view, in three very significant ways. In some instances, there were complete deletions in areas that were material to our investigation. In other instances, there were whole new portions added to the diary in ways that materially altered or changed the diaries, again, on issues related to our inquiry. And third, there was a combination of the two preceding, some deletions and interlineations in a material way. I believe it was that issue to which the chairman addressed himself, that this was a calculated and designed effort to deceive and mislead the committee with respect to the nature of the charges.
Now, question about sexual misconduct. Earlier you mentioned, you said this was only relevant regarding the jobs. The jobs for his former wife, the jobs for his wife.
I don't try the question if I misspoke. I don't.
What's the question,
Charles?
Well, the diaries were altered not only because of the job charge, but also sexual misconduct.
That's correct. That's correct. That's correct, yes.
Do you have the 67 votes?
Oh, I have no idea. I certainly hope so.
Senator McConnell, you said earlier that the appropriate response would be resignation. But in view of the image of the Senate, would it in fact be good, you think, to rehabilitate this image if the Senate, full Senate, had the opportunity to vote?
My view is the important thing that the committee, having made its recommendation after this exhaustive investigation, is for Senator Packwood to leave. And it seems to me the most dignified way to do that would be to resign. But obviously that's his decision, and we're prepared to move forward if that doesn't happen.
I would agree with that and simply point out that all of the information upon which the committee relied upon in making its decision is contained in that record. So no information is going to be withheld. You'll have an opportunity to see it all, and I would agree that the most dignified course of action is resignation.
Didn't you witnesses that he supplied you with that he says contradict some of the...
Yeah, we interviewed how many... I think we have the answer to that. Hold on a second.
Well, you're watching Channel 2 News live coverage of a press conference by the Senate Ethics Committee on their findings of the Senator Bob Packwood investigation, and some very harsh words being said by those who investigated the case.
But let me just say, while the chairman is waiting for that answer, the point that I think that the chairman has made, that all of this was moot by reason of the fact that Senator Packwood, on 2 prior occasions, first in appearing before the committee, expressly declined to request a hearing. He made that decision. He had the right under our rules to request a hearing. He chose not to do so. And later, as the chairman has pointed out, after our decision to release all of this information was made and announced publicly, the senator one more had an opportunity to express his view, and when he voted with the prevailing majority of 52 in opposing a public hearing, obviously he did not think that that was important then, and the important part is that our decision on each of these actions deal only with the charges that were filed in May of this year, not with respect to the 2 new complaints.
Senator Robert, you said that this was the first disciplinary action taken in the Senate based on sexual misconduct. Do you think that's because of the egregious nature of this particular case, or is it a sign of the times that we are in?
Certainly it's the egregious nature of the case. The conduct that Senator Packwood is convicted of by the actions taken by the Ethics Committee would have been unacceptable at the time Columbus discovered America. I mean, this is not some new subtle evolution of what is acceptable behavior. This conduct was unconsented, unwanted, offensive, repugnant, and I believe that you will find the same when you read the record.
Senator, did it border on criminal? Did any of the behavior border on criminal behavior, sexual misconduct?
Well, I think that our recommendation will speak for itself. We've laid it out for you, what our finding was. I think it's pretty complete.
You said that the last 2 charges were not part to be released today.
Those individuals,
for the expulsion.
right, those individuals were interviewed and corroborating witnesses were spoken with, but it was the view of the committee that to start the procedure all over again to deal with those 2 witnesses would have only delayed the inevitable. But we did put a paragraph in suggesting that we did find those charges to be credible, and even though they're not technically a part of our recommendation, we did speak to the witnesses and corroborating witnesses and included a paragraph saying we found those to be credible.
Well, having that is, to me, is a basis for saying I want to open this up and have hearings. You're not placing as much weight on these last 2 charges.
No, I wouldn't say that. I think it's entirely related to when they came in. And if you look at the fact situation, they were very similar to the other occasions, leading you to believe that it only substantiated the pattern.
Can I follow? Does that mean that prior to these 2 new charges, you were both ready to vote to expel? And if the evidence was so overwhelming, why didn't you just go ahead and do it?
Well, as you know, the hearing issue split the committee and the Senate. I felt we were ready to make a decision in this case in late July, and that was my preference. It was only yesterday that we were actually able, because of the hearing diversion, which went on for a couple of months, it was only yesterday that we were actually able to sit down with each other and discuss penalty, and then we found ourselves in remarkable agreement.
You would look, so if I'm clear on this, you both would have voted to expel last July had it come to a vote then.
That would certainly be my position. As I indicated in my statement, it was my sense, after looking at all of the evidence, that that would be the only acceptable course of action. I was prepared to so vote. But I want to emphasize the chairman is correct. That the penalty was not discussed until yesterday.
Yeah, I don't have a precise date upon which I concluded that I ought to vote for expulsion. But I think the important thing is where we all ended up. Once we were able to sit down and discuss the appropriate penalty for the offenses that we found.
Where, when, and how can we get copies of these documents?
Yeah, can somebody handle that? Okay, I'm told here that the documents will be available at 1 p.m.
Why do we have to wait an hour?
I can't answer that. In Dirksen, G11 in Dirksen. G11? Is that right? SSDG11.
You mentioned the word frightened, sir, in your statement today. The word frightened came up. What about the intimidation aspect? Do you believe Senator Packwood
It was not in the list of particulars, but wrapping up this long investigation, is there evidence that the senator or members of the staff tried to intimidate these women that came forward?
We considered the issue.
Yeah, we considered that issue, and as you know, that was not in the bill of particulars.
Senator, you said that alteration of the diaries was a crime. Was any of the sexual misconduct a crime? If any of these women had immediately got on the phone and called the police, would there have been a criminal act in some of these cases?
I don't know the answer.
Well, you answered it in terms of the diaries.
Well, let me just speak for myself. Under the law, any unconsented, unconsensual contact can be a battery. A battery is defined as a crime. It can also be the basis for civil action. So my answer would be yes, those actions could have been a criminal.
Justice has already gone into this one time and chose not to prosecute. That does not impact on your decision at all. You take that into account?
That was only the jobs.
That was only the jobs issue.
Senator McConnell, as a Republican, do you have any concern, or have other Republicans spoken to you about a concern that removing the chairman of the Finance Committee at this time would be disruptive to moving the legislative agenda? Does that come into your...
Well, let me just say, no one has said that to me, but I don't think any senator is indispensable, and I think that it was important for us to complete our work at the earliest possible time and make our recommendation to the Senate, and we've done that.
So, this could be read what you are trying to do is out of proportion what Senator Packwood did. He made some crotchety advances. He didn't steal, he didn't kill, he didn't rob anyone, and you are trying to treat him as kind of outlaw. Yeah. So to what extent are you sure that you are in the boundaries of reason?
Yeah, well, I don't want to be rude to you, but my view is that an obvious violation of Title 18, Section 1505 of the United States Criminal Code occurred here. And I think the recommendation that we made is a logical response to an apparent violation of the criminal laws of the United States of America.
Let me just add one additional point here. A member of the United States Senate should be held to a higher standard of conduct, in my view. I believe that the actions were criminal with respect to the alteration of the diary material, but I don't believe that our actions are disproportionate at all. I believe that they're the only course of action that would provide justice in this case in light of all the circumstances.
Is that the greater transgression?
I think we've just about covered the waterfront.
We have time for one more question. One more. Just one technical question.
The leadership conference.
What?
Senator McConnell, you met yesterday with members of the leadership conference in Senator Dole's office, and did they give you any indication then whether they were prepared to support the committee's recommendation? Some expressed shock after.
No, I think they listened to what I had to say very politely, and I departed.
Senator, it's just, I'm unclear, maybe everyone else has it, but on the referral situation, I think the question is this. Yes, the committee did vote to recommend the referral, but does the full Senate now have to vote on this before it can...
No.
Just the
actions, no.
Senator McConnell, I can clarify one earlier comment you made. You said that you reached a decision at some point that there was nothing short of stripping him of his chairmanship. And I was unclear whether you were saying that was based on what you believe was a criminal behavior involved in this case.
Absolutely. I don't mean to diminish the other charges, but which are serious. But for me, the apparent, obvious violation of 1505 is the most grave violation. Thank you very much.
Thank you.
Yeah.
We have just seen an incredible piece of political history. In a forthright presentation, Senator Bob Packwood was taken to task publicly following an investigation by the Senate Ethics Committee. As we have seen during the past almost 55 minutes, Senator Mitchell McConnell, Senator Richard Bryan, in very harshly worded statements, accused the senator of being guilty of sexual abuse, of manipulating the system for his own financial gain, and of obstructing the investigation. They said it was egregious abuse of power.
Yes, that was sexual misconduct. They didn't say sexual abuse, but definitely serious words, saying it was outrageous, repugnant, intolerant. Definitely harsh words for the senator. Political reporter Mark Hass has been following the Packwood story since it broke. And could this be the fatal blow to the senator? How can he ignore this?
Janice, it doesn't look like there is anywhere else for him to go here other than to resign, because if you play this out, that there would be an expulsion vote on the floor of the Senate. Remember that Mitch McConnell, the Republican who we heard from that gave the scolding of Senator Packwood this morning, he is an ally and a friend of Bob Dole, the majority leader and not so incidentally a presidential candidate. If you play this out, there will be an expulsion vote, and although it requires a 2/3 majority, it's hard to see how it would not get that 2/3. So he probably does not have the votes to survive that. And if he does, I don't think that Bob Dole is interested in having Bob Packwood hanging around the U.S. Senate like a stray dog for the next year while he runs for president. So if you play that out, it doesn't look like he can survive an expulsion vote. And the best thing for him to do, even aides we hear are telling him, is to gracefully resign with some shred of dignity if he has any left. You heard Mitch McConnell, a reluctant supporter of Packwood during this process, today saying he has gone so far that he has not only slipped over the edge of Senate ethics rules, but he has even broken the law. This is what McConnell said about Packwood's alleged altering of the transcripts and tapes.
If this were a criminal court, Senator Packwood would likely receive 10 to 16 months in prison as a first offender under the federal sentencing guidelines. The law itself allows prison sentences of up to 5 years. This is a gravely serious offense. Historically, the Senate has waited until a member has actually been convicted of a felony before expelling a member. In this unusual case, however, the crime was not committed out there, if you will, out in society, but it was committed in here.
Now, Janice, that is a Republican on the side of Bob Packwood and Bob Dole, and he is making some pretty strong statements about Senator Packwood. It's my sense that the Republicans who voted 6-0, the 3 Republicans on that ethics committee, finally just got so fed up that they had nowhere else to go other than to recommend that he be kicked out of the Senate.
That was one of the questions that was brought up several times. Will there be criminal prosecution against Packwood? I guess that's up to the Justice Department. Mark, you have talked to Packwood many, many times. One of the questions that came up during the conference was, is he suffering from delusion about the seriousness of these charges? What is your opinion on that?
I am not going to guess as to his frame of mind through all of this, because he has vacillated so far. He has apologized, unapologized. He has been aggressive. He has said he's not going to respond to some of these comments by women. Then he said he was going to fight fire with fire. And I just don't think anybody who says they understand what he's thinking right now really understands what's going on.
A sad day for Senator Packwood. Thank you for your comments. Mark Hass from the newsroom.
Well, clearly the senator has gone on the offensive in all this. As a matter of fact, he's gone nationwide with his public attempts to try to hold the status quo. Senator Packwood told ABC this morning that he has absolutely no intention whatsoever of resigning. He talked with Charles Gibson on Good Morning America.
You leave open the possibility of resignation.
I have no intention of resigning.
None. You will fight this through to the end.
I have no intention. I want the public to at least see the charges and see my responses, not just in a written record where I've never had any chance
to
face my accusers, but at least to have a chance to have the public see them and see me.
You say you haven't had the chance to face your accusers, but are you saying these women are not telling the truth, Senator?
Oh, no. In many cases, here's my problem. There are 19 complaints, although I want to say 19 complainants, actually. Only one in the last 12 years. But of those 19, unfortunately, 10 of them I cannot remember. I don't know them. And of the incidents that they complain about, there's only 5 that I have any recollection of. 2 of them I dispute. One of them I have some slight difference of opinion with the woman. Two of them I agree with. But the rest of them, it isn't a question, are they lying or not lying? I can add nothing to what they say.
And those were the comments by Senator Bob Packwood on Good Morning America this morning. Of course, the documents containing the findings of the Ethics Committee will be released within the hour, and as soon as we get information on those documents, we will pass it along to you.
And very much the credibility of the senator has been called into play. We will have continuing coverage of this significant political story during the course of AM Northwest, again at noon today and throughout the day. Make it a good day.
This has been a Channel 2 News special report. We now return to our regularly scheduled program.